I'm Danny Pearson with 350 Eugene, and today we're speaking with Mary Christina Wood, the Phillip H. Knight Professor of Law, Faculty Director of the University of Oregon's Environmental and Natural Resources Law Center, and author of the book Nature's Trust, Environmental Law for a New Ecological Age. Thank you so much for taking time out of your day to speak with us today.
It's my pleasure.
Thank you. We were going to start a little bit about yesterday's hearing, Juliana v. United States at the Ninth Circuit in San Francisco, and I believe you were in attendance.
Mm-hmm.
So, last year, U.S. District Judge Ann Aiken wrote that too often the courts have been cautious and overly deferential in the arena of environmental law, and the world has suffered for it. After yesterday's hearing, what do you think has changed in terms of the government's argument that this case is just too extreme and burdensome to address?
Well, each day we don't address climate, it gets much worse. And the government, this particular administration, is really not recognizing the gravity of the climate harm that children and the rest of the world face. However, nothing really changed yesterday. It was an oral argument on a motion that just generally is the type of motion that's rarely granted. It was a motion for writ of mandamus. The government put forth this motion because they lost the motion to dismiss. The district court said that the youth had claims and they should go forward to trial. And the youth plaintiffs were proceeding in discovery, which means you try to get facts from the other side. The government first made a motion to appeal that ruling by the District Court of Oregon and lost. And that was a final judgment. I mean, in the ordinary progression of cases, if a motion to dismiss loses and a motion for an interlocutory appeal loses, you just proceed to trial. But the Trump administration came in with this very obscure tactic that had very little chance of succeeding from the outset. It's called a motion for a writ of mandamus. And what that basically means is it comes in against the district court itself. In other words, it's a motion challenging not the youth plaintiffs, but the District Court of Oregon. In fact, the proceeding was called, yesterday, was called United States versus United States District Court of Oregon. And basically, the government is asking the Ninth Circuit Court of Appeals, which normally wouldn't come into play until after the trial and when an appeal is filed, the government's asking that court to just step in right now and cut everything off. Well, that's an extraordinary sort of ask. And even the government attorney yesterday recognized that at the outset of his argument. These are extraordinary and rarely granted. And the clear focus of the judge's questioning, particularly two, but even three at one point, was, you know, if we grant this motion to just create an appeal before the normal progression of the case, wouldn't we be asked to do this in every single case that comes before us? And wouldn't that open the floodgates to our court, the Court of Appeals, and also wouldn't it create this double layer of appeal? You see, if this succeeded in this case, everybody would want to file motions for writs of mandamus to get an early appeal where the legal system isn't set up to do that. And so the Ninth Circuit Court of Appeals was concerned, that panel very concerned throughout the hearing. What would be the implications of this? Wouldn't we be swamped with these kinds of motions from everybody? And then wouldn't we end up hearing two appeals in many cases? The first under this motion for writ of mandamus, and then the second, should it fail, the regular appeal process. So so in terms of what happened yesterday, you know, I would say not much changed in the case, except I think every hearing results in the youth gaining momentum because more and more people hear about it, and more people start thinking, oh, this is really a litigation strategy that has some promise and that really gets at the heart of what is going on.
Gotcha. Thank you for that. And moving on to a little bit of material from the book. Nature's Trust was published in 2014, and a great deal has happened, both politically and environmentally since then, to say the least. Your book details climate science and science denial and environmental deregulation that took place under the George W. Bush administration, as well as the inadequate response to regulating carbon emissions during the Barack Obama presidency. Today, it's even worse, obviously, under the Trump administration. If you would, talk a little bit about the public trust doctrine as a remedy, as a constitutional foundation to protect the public assets of our water, lands, and atmosphere.
Yeah, the public trust principle goes back to really ancient Rome. It's the foundation for democratic societies around the world. And so it's a principle in law that is expressed across this country, in virtually every state, and also in countries throughout the world. And it really just means that the government, as the enduring institution through time, the government that we, the people, authorize, acts as a trustee over the resources that we rely on for our survival. So that would be the air, the waters, the wildlife, the oceans, the tidelands, etc. And as trustee, it doesn't just have political discretion to damage resources, because those resources are public commons property. So they are owned in stewardship by the government for the people. They're actually owned by the people, but the government administers them. These resources are owned in stewardship by the people, and the government is merely a trustee and has obligations as a trustee to protect those resources for present and future generations. You can imagine if a government were to use its vast power over these resources, power that environmental statutes give it, over these resources, to favor particular industries for their profit purposes and not to favor the people, you can imagine this nation would move towards its own expiration, because the people need clean water, clean air, a stable climate system, an ocean that can support marine life. We need all that. And we not only need all that, it is public property. So the public trust doctrine is a constitutional principle that puts a limit on government in terms of how much damage it can allow to these resources. It is different than statutory law. You know, many people have grown up with these environmental statutes, the Clean Air Act, the Clean Water Act, all of those. And environmental statutes are passed by Congress. They're not constitutional. The public trust is the constitutional foundation that underlies all of the statutes and all of the regulations. So in an era like the one we face right now, where we have a president intent on developing trillions of dollars worth of fossil fuels, and a Congress that's not willing to stop him, in face of that threat to future human survival, we really legally need to draw down to the foundation of law to a constitutional principle, because it is the only principle that really provides a check on the otherwise vast power of the executive and the president.
Indeed. And this is kind of a two-part question here. If the Juliana v. United States Atmospheric Trust litigation case goes to trial, the 21 youth plaintiffs, Dr. James Hansen and their legal team, and other expert witnesses are able to present scientific evidence for the government and industry knowledge of the perpetuation of destructive practices over many decades, what part do you think science in the courtroom will provide in presenting convincing arguments that can withstand legal challenges from the DOJ?
Well, the trial would be immensely important on many levels, and there are actually many parts to your question. On one level, the American public has never been told the story of the government's fossil fuel policy and how it is known for decades, how literally government officials have known for decades that promoting fossil fuels would endanger citizens around this time, and then moving on to graver circumstances through the end of the century and beyond. That story's never been told. We hear snippets of catastrophe. We hear about the firestorms in California, the rising sea levels, the superstorms, the droughts, the floods. But the American public has never been told in a concrete and cohesive way how fossil fuel policy has driven all that and how it has been known for decades. A trial is that forum that is a fact-finding forum that the press covers. And on one level, which is not the legal level, but a different level, it is of paramount importance that the American public understand what government's role is in causing the climate catastrophe. Because if the American public doesn't understand how it's caused, it won't take action towards a solution. So on that level, that's outside the legal forum, but it's still very important. In terms of the law, the evidence developed is developed with the idea that the plaintiffs will prove a public trust violation and a constitutional violation, that government has indeed violated the constitutional rights of young people to a stable climate system. And once that is demonstrated, then the court will move on to the next stage, which is developing a remedy to address those violations. And those are two different stages. I mean, the trial stage is where we find facts. We figure out how much did government know. Well, you know, reports on the books that you and I have access to already show a great deal was known. But I think even more will come out at trial. And then the court will issue rulings finding whether or not the government breached its public trust and other constitutional obligations. And then if the court finds the government did breach those, there will be a remedy phase.
Okay. During the Obama administration, the President and the Department of Justice admitted to many of the plaintiffs' complaints in the government's original response to the lawsuit. What effect do you think that these factual concessions may have on the government's legal strategy moving forward?
It's a really incredible thing when you think about it, because the outgoing administration finally submitted an answer to the complaint just before Obama left office and did admit how very dire this catastrophe is and did admit to government's role in it, at least in part. And so the Trump administration lawyers are pretty much stuck with those admissions. How will it affect their strategy? I think it's pretty clear. The Trump administration lawyers know it would be really stupid to challenge some of the admissions because the science doesn't support alternative admissions. And so they're just trying, I think, to delay. The more delay that happens, we must remember that every day of delay, the fossil fuel industry makes money. And so with the tobacco litigation, with all the regulation all the public momentum trying to seek regulation of lead in gasoline, you know, in countless instances, industry's objective has been to delay regulation. The Trump administration is so aligned with the fossil fuel industry that I think its paramount objective and strategy is to delay the litigation. And that's why we've seen this obscure motion for writ of mandamus. It has caused delay. That motion was put to the court several months ago. We just now saw a hearing. It may be another month before the Court of Appeals writes an opinion. And so clearly that is the strategy.
And the Clean Air Act was signed into law by Lyndon Johnson in 1963 and was later amended a number of times. Can you give us a summary as to why different environmental laws such as that one, the Clean Water Act, Endangered Species Act, formation of the EPA in the 1970s, have failed to protect the public from institutional failures of agencies charged with regulating greenhouse gas emissions and the extractive industries that perpetuate these destructive practices?
Yeah, well, the Clean Air Act and those statutes were passed in an era where Americans were fed up with pollution, wanted change. And it really seemed to be the dawning of a new day with these statutes. There was tremendous hope and confidence that they would work. But what happened was they really began a huge administrative experiment. because Congress can't be out there on the streets regulating all of the behavior under the statutes. And so Congress delegated tremendous authority and discretion to agencies to then implement the statutes. Well, that was one grand legal experiment. And after 4 decades, we figured out the problems with it. Because the agencies were always assumed, and by that I mean Fish and Wildlife Service, EPA, the Department of Interior, the Forest Service, you name it. The agencies were always assumed to be neutral creatures, that they would just take those statutory goals and implement them. And nothing could have been more off the point of what happened. In fact, the agencies were lobbied intensively from the get-go by industries. And so industries have regulatory specialists lobbying the agencies every single day to ease up on regulation, to not enforce, to issue permits. And with that enormous political pressure over the decades, these agencies became very political creatures. And that is why you find even today, there's been no comprehensive regulation of carbon dioxide under the Clean Air Act, even though the authority has been there all along. And that is really the case with almost every agency that is authorized. They have done some protective things, they've taken some protective measures, but overall we are losing not only the value of individual resources, but now we're seeing system-wide damage that is literally threatening the survival of humanity later in the century.
Right. In terms of the macro-scale remedies that are being sought with the Juliana case, do you think that a judgment defining government's fiduciary obligations as trustee to the atmosphere will be issued, especially after yesterday's suggestion by the court that the case moving forward would be improved by narrowing the scope of the focus?
Yeah, there was one particular judge suggested narrowing the scope of discovery, and that is a lot different from narrowing the scope of the remedy. The remedy is a different stage, it's a later stage, and so I think what the judges were referring to yesterday was the focus of fact-finding being narrowed, and in fact it has been because the fossil fuel industry, which had intervened early in the case, left the case back in June. So all of the discovery against the fossil fuel industry was no longer warranted, and so that's been withdrawn. In terms of the remedy and the scope of the case, I guess my first reaction is kind of a non-legal one, and then I'll give you the legal reaction. The non-legal one is we face a climate reality, and the law at some point has to face the reality that nature's imposing upon us. The law's very purpose is to prevent harm, and Justice Holmes once said, famously, the law is the felt necessities of the times. Well, we've let this problem go so long, decades in fact, even after government has known all along that this problem was becoming worse and worse, that we are now in this crazy, mind-blowing point where we're literally facing thresholds that if we go beyond those, the climate system itself could spin out of control because of nature's own feedback loops. There are judges now coming to realize that. Certainly not all judges. In fact, I had the feeling yesterday in yesterday's hearing, I don't think the word climate was really mentioned all that much, and certainly no climate science came into the picture. It was sort of this detached, obscure motion, and part of me just wanted to keep in mind the mind-blowing reality we do face. I think more as judges come to realize the moment we face and the science behind it, they will creatively fashion a remedy that respects their jurisdictional boundaries and yet still has an effect on the ground. The remedy cannot even be discussed before a trial is held and the court issues findings from that trial. And I think what we saw with one judge in particular was sort of the hopscotch effect of going ahead and trying to just wrangle the remedy. That is very far down the line, and remedies are creatively structured by judges in all cases to both get at the harm, but sometimes not all the harm. Sometimes judges will recognize that certain parts of the remedy might be outside their purview, and they creatively address that circumstance. But I guess what I do want to say is that this case is markedly different from statutory law. The statutory remedy would simply, if you found a violation of statute, the typical remedy there is to remand the case back to the agency that violated the law in the first place. And it sort of puts the remedy in the spin cycle of administrative discretion.
We've already detailed
We've already done that.
The failings in that.
Yeah, and so a remedy here would, the remedy asked for by the plaintiffs, the remedy asked for by the plaintiffs is a comprehensive plan to recover. Let me back up. The remedy asked for by the plaintiffs is a plan to decarbonize, to protect plaintiffs' constitutional rights. And in many cases, courts have issued institutional remedies, like the Brown v. Board of Education case, or prison cases, some very complicated land use cases, treaty fishing rights cases, educational offending cases. Courts are very accustomed to tackling the remedy part of a case after principles have been declared. This is nothing new for courts, but these remedies tend to be outside the narrow confines of the statutory laws.
During the time of Trump, would it be even possible to implement meaningful, urgent enforcement of a historic climate recovery plan? Is that even possible?
You know, I think when we talk about what's possible, we have to always just ask, what is possible within nature's reality? Yes, it is very possible. We are dealing with a president intent on developing fossil fuels, but the basic structure of law today is just as it was 150 years ago, 200 years ago. The Constitution sets the boundaries of law, and agencies must comply with the constitutional mandates that are set forth. And just as in school desegregation, yes, things changed. Mm-hmm. After a certain case, there couldn't be desegregation anymore. So the law is sometimes a catalyst for change. Is it the panacea for change? Never. Mm-hmm. But it's a crucial, because change requires all parts of society. Sure. It is a crucial catalyst. And I think sometimes we forget, too, that the law has rippling effects. When certain declarations are made, people from the business sector look at decisions in front of them in a different way. They may say, oh, we might face liability for continuing down a fossil fuel path. So there's multiple approaches in the law, and absolutely this case can and will make a difference.
Well, it's good to hear. I'm gonna read a quote from your book and frame a question around the quote. Law must tap into the deepest moral understandings of humanity, not only to maintain credibility and respect in society at large, but also to inspire citizens to participate in democracy. When the citizens lose sight of the purposes served by the law, they cease to engage in their own government, and I'm paraphrasing here, resulting in the assumption that they have power when they actually do not. Based on your quote about moral understandings, how do you feel that grassroots supporters, of the Our Children's Trust federal case and other climate-related legal cases worldwide can be most effective in engaging in street democracy, environmental advocacy, and in adding their own voices to the biggest moral imperative of our time, i.e., how can the legal and activist community work in a more coordinated and productive way to influence public opinion and the courts?
That's a marvelous question. What I want to say is that the grassroots is everything, that it is really everything. It provides the moral wellspring that influences certainly courts, government regulators many times, perhaps not this president, but people in agencies. It defines the conversation of what is possible and what is right. So the grassroots effort, I would hope, just gets bigger and bigger and bigger. In terms of what tangibly can people do, I think the most important thing right now is simply announce the emergency in every form possible. We are not dealing with a climate situation that we have 30 years to resolve. We did deal with a climate situation of that sort 30 years ago. Now we are at this really crucial moment in human history, and it's something that the American public has a hard time understanding, because rarely does nature deliver to us a kind of deadline where if we miss it, we lose control. We're used to humanity having control over nature, right? That's not the case with climate. Because of tipping points, if we heat the earth too much, if it gets too hot, it triggers feedback loops that then send the situation out of control into runaway heating that really humanity can't survive on a broad scale. And that's what legislators, politicians, and many in the public do not understand. So just for a very concrete example, there's many such tipping points and thresholds, but one example is the permafrost in the northern latitudes. That holds immense amounts of carbon dioxide and methane. So much that if it starts melting and emitting those massive amounts, it becomes the equivalent of sort of an atmospheric tsunami. It overwhelms all the emissions we could possibly come up with. And so there's already melt occurring because the earth is heating. If that really gets going, then we lose control over this situation. So I think the grassroots is vitally important. It's been vitally important to every single movement. Movements have started there, and they've only grown from there. And that is true in this climate case. Climate cannot be a political issue. It is a survival issue. It's a moral issue for our children and for future generations, and even for just humanity across the world, because there are climate deaths mounting every single year from devastating catastrophes.
How effective are legal decisions without constant pressures from society to change the way we implement and achieve our visions of a more just and environmentally healthy world?
Well, I think the question you're asking really goes to what is the role of law and court decisions in society. And what I love about this particular Juliana case and the atmospheric trust litigation is that it is just totally connected in with a grassroots climate movement. We can never pretend that the courts can solve all the problems, or that they should solve all the problems. Climate ends up being our individual responsibility. And I think that the grassroots efforts make the connection between our individual responsibility and the court processes quite well. At least here in Eugene, they really do. But we must, every day, as individuals and families and businesses and groups, must always wake up and just accept our personal responsibility for this climate crisis and ask, what can I do differently today that I didn't try yesterday? How can I reduce my own carbon footprint, and how can I influence others around me to do the same? And how can I broadcast the climate crisis, the climate emergency? We know we talk about the weather with strangers a lot. Can we broadcast the climate situation in those conversations without it becoming political? I think we can.
All right. Thank you so much.
Thank you so much.
We'll be following the progress of our Children's Trust youth plaintiffs and pulling for a transition to a 100% renewable energy future. Marry your scholarship has been instrumental in getting us to this point, and we'd like to thank you so very much for your vision and your leadership.
Thank you so much. And thank you for all the citizens that do so much, for how they wake up every day and work on this climate crisis. They're heroes.
Sing it with your hands up in the air, freedom. And sing it to the land that we protect, freedom. And sing it to the people, bring them hope, free them. And sing it to yourself, never forget your reason. So sing it with your hands up in the air, freedom. And sing it to the land that we protect, freedom. And sing it to the people, give them hope, free them. And sing it to yourself, never forget your reason. Break free. Thank you.